Hi there. This is James Drennan, and I'm going to cover what is in your estate plan notebook. And this is very much a homemade video. I'm going to be doing things like screen sharing like this. Ooh, there we go. And I hope you can bear with me. A lot of people would prefer to have a video than read what's going to be in their estate plan notebook, so that's what I'm going to cover really quickly here for you, what you can expect. So open up, and you've got a cover page, and then over after that, your estate plan notebook is going to have let's go like that, 5 tabs, okay? And I'm going to describe, those 5 tabs are for the 5 sections in the notebook, and I'm going to go ahead and talk about what each of those are. But really quickly, I want to turn to the back of your notebook. That's where I've printed out, and you're going to find your cards, your wallet cards. There we go. So your wallet cards obviously are what you want to take with you and keep in your wallet, your purse, whatever you use. The first one is going to be if this is a trust-based estate plan, you need to know how to sign as a trustee when it's for your official signings. And so the first 2 cards are how to sign as a trustee, so you don't forget and you don't have to memorize it. It's going to be in a card in your wallet. After that, I have 2 copies if this is an estate plan for 2 spouses, for a married couple. Then I'm going to have advanced directive notifications for each of you, and each of you will get 2 copies. So you can keep one, maybe you want to put it on the fridge, and the other one keep with you, but it's going to show that you have an advanced directive under Idaho law, and it's going to show who your health agents are. So that's very useful to have on you in case of an emergency. Then I've also included 2 business cards in there so that you can continue to stay in contact with me, and those cards will be wonderful to give to someone else who needs some estate planning, because referrals are the heart of my business. So the first section of the notebook is called your executive summary, and it's a written summary and explanation of everything that's in the trust notebook. So section 1, the executive summary, it's where you go back when you have questions, or it's what you read when you want to understand what's in there, and when you don't have, when we're not meeting together, or when our time meeting together is over. Refer back to your executive summary to know what's in your notebook. It says in there one thing that I want to reiterate, and that is, don't write on the documents in your estate planning notebook. You can't make changes just by crossing things out and making additions. That's not valid, and it could invalidate portions of the work I've already done for you. So when you need to make any changes, and it says it right here in the executive summary, but I'm going to tell you again right now, just contact me or contact any other lawyer that does estate planning to make an amendment. Don't just write on the documents in the estate planning notebook, please. Section 2 of your notebook contains a lot of documents, so let me explain briefly what they are and how they operate. First, you're going to find your trust agreement, which creates your revocable living trust. While you're alive, you manage and control the trust, unless you've made other arrangements, but that's typically how people do it. And there's a assignment of personal property to the trust, so that all your stuff is now owned by the trust, and it's not owned by you individually. Now, that does not include titled assets like cars or houses. After your trust documents, you're going to find your last will and testament, and there will be one for each of you. Now, you might ask, why do I need a will if I had just created a trust? It's because you need to pour over any assets that you haven't placed into the trust when you die. And that's called a pour over will, and that's why you have wills included in there too. After the wills, you're going to find the power of attorney documents, starting with the financial power of attorney. Now, these power of attorney documents, they operate when you're incapacitated, and they don't operate after you are passed away. But if you're incapacitated and can't make your own financial decisions, the durable power of attorney for finances names a person called your agent who will make those decisions for you to take care of you. And then after the financial power of attorney, there are the healthcare documents in two parts. The first part is a power of attorney for health, and that names a person who will make your healthcare decisions when you can't and when you're incapacitated. But after that, Idaho law allows a living will, and so you're going to have a living will after that. And that only operates when you're in a terminal condition or vegetative state and you can't communicate your own wishes. So it communicates your wishes ahead of time about what kind of life-sustaining treatment you want or don't want if you reach that condition. And then finally, we have, I call it the disposition of remains, instructions for final arrangements, which is your funeral plans and what you want to happen after you've passed away. Now, if you don't do that ahead of time, you have your healthcare agent actually has the authority to do it for you, but most people want to do it ahead of time. So that will be included in Section 2 right after the health power of attorney and the living will. Section 3 of your notebook contains the filings. And let me explain what happens at the signing. You are going to sign these documents that need to be filed, which I'm going to file on your behalf. But you're not going to walk home with the original documents. I'm going to use the originals and I'm going to file those for you. You will walk away from the signing ceremony with scans of absolutely everything, which I'm going to email to you later. Or if you bring me a flash drive, I'll load it to a flash drive before you leave. But the filings, well, I need the originals to file. And then once I get them back from where they have been filed, then we'll set another date where I give you those copies, or I can set it up where I can email those to you. But then after that, Section 3, is empty. You need to take the accepted filing documents that I give back to you and stick them into Section 3. Not that hard, but that's how it's going to work. So what's in there exactly? First off, the registration of the trust. Under Idaho law, there's no penalty for not registering a trust, but you do need to register because it's required. And so I'm going to register your trust. After that, there's going to be a warranty deed because this is in the case that you own a house and you need to transfer that house into the name of the trust. So that's what the warranty deed is for. After that, you are going to be, I want to help you get your homeowner's exemption after you transfer your house into the trust. So there will be an affidavit and an application for the homeowner's exemption so you can get the tax break that you want. Section 4, it does what's called funding the trust. And funding the trust just means transferring assets into the trust. This is really important. This is one thing that some of the cheaper plans out there, unlike mine, aren't going to help you with this. They're just going to give you a list of what to do and make you fund the trust on your own. I'm going to help you with that. I have funding letters in Section 4 for you that I'm going to send off to the places they need to go. So that gets the process started. Sometimes a letter that I send on your behalf isn't quite enough because the institution that I send it to requires you to do their own kind of paperwork. So for 30 days, we need to work on this together to make sure we get the funding of the trust done. If I send the letters off and then you get a response back that says they need something else, talk to me so we can work it out so I can help it get done. So that's the first thing I do, and we'll get everything funded. But then life goes on. So we're going to be doing this for 30 days, and then you're going to live your life, and you're going to keep moving things in and out. You're going to have new assets, and you're going to sell things, and you're going to change your mind and want to make changes. So I'm going to give you blank funding letters. The blank ones are for you to fund the trust with the new assets you come across, whatever they may be. So you'll have blank letters you can do on your own after our time together is over. After those funding letters, I was going to say, there are also, we're going to get your financial accounts changed over, make sure that you have I'm going to double check them because you may already have this, but we're going to check that your accounts, like your bank accounts and your retirement accounts and such, have the right beneficiary designations so that those kinds of accounts will just directly pass to your beneficiaries after you pass away. So I'm going to double check that with you, and if you need to make any changes or you haven't done it before, then those letters are going to be in there as well, and the blanks. So you actually, for those kinds of accounts, if you designate a beneficiary for your bank account, for example, you can go online and change that. You're not going to probably need me or another attorney to keep that up to date. So do that on your own, and don't forget to do it, please. Then finally, there is, I want to make a note about titled cars. I mean, cars all have titles. I want to make a note about your vehicles, and maybe a boat might be a titled vehicle or titled as well. So those, you can transfer it into the trust. That's not what I'm going to do, not what I recommend either. I think I'm going to show you a way where you take the title and you pre-sign it, and then keep it in a safe place, so that when you pass away or when you're incapacitated, you've already signed it away, and someone who's going to help you out at that point or wrap up your estate at that point is just going to fill in the person that it goes to. So pre-signing is really the best way and easiest way to deal with your cars. Now we're in section 5. This is did I say that right? Yeah, section 5, successor trustee resources. So let's explain what that means. First of all, you are the trustee of your trust while you are alive and have capacity. But you also name a successor trustee. That means the person who serves after you. That might be your spouse, or that might be your children. And I really recommend you're going to have more than one. You have the first, and then if the first can't do it, then there's the second, and so on. So that person who takes care of the trust after you is the successor trustee. This section is all the resources that person needs. Now, I'm going to notify them that they've been named, and then they'll have a copy of the trust. But when it comes around to the time that they need to serve, this section is really made for them, and that's where they need to go to. Then let's see, when the time comes around, they need to file an acceptance of trusteeship with the court. Because remember, we registered your trust with the court. Now we can file an acceptance of trustee by the person you named to take over after you. And I can do that if they come to me, or another attorney can do that, but that needs to happen so that they can work on behalf of the trust when they need to, when the time comes. I also want to mention there are some optional documents in here that are going to be forms for you to fill out. Optional, but what's the term? Highly recommended. Okay, I want you to do these. These are for you to do later after you walk away with your estate planning notebook. So in there, for example, there's a family information sheet, which is going to have details about your life, things that might be hard for other people to know if once you're passed away. There are people to notify of serious illness or death. You're the only one who knows who you want to have contacted if you get sick or if you die. So fill that out, please. There's also a list of professional advisors. That's going to be really helpful with the person who serves your trust after you. There's important records and the location of passwords. How is anyone going to know unless you write it down and it's there and available? There's a form for you to fill out, and I'd like you to do that for credit card accounts and utilities, so that they can pay things as long as they need to. And especially if you're incapacitated, they need to know what the bills are, and so they can keep paying them for you. Then finally, there's a list of medications. Now, I also mentioned that if the successor trustee feels like this is overwhelming, they can contact me at Legacy Legal Services and James, and I will do my best to help out. But this section is made for them so that they can do it on their own if they really feel like they want to.